So hello everyone and welcome back. Today we'll be covering the writs part as well as some other topics which are very essential for for any of the exams and which are a part of the fundamental rights. These are all interconnected. So we are covering the most important part in Indian polity, that is writs. Till now we understood fundamental rights, but the real question arises that what if your rights are violated? Who will protect you? Now this is where writs come in. Writs are legal orders which are issued by the courts to protect your fundamental rights. Under Article 32, you can directly approach the Supreme Court, and under Article 226, high courts can also issue writs. Now that's why writs are called the ultimate protection mechanism. There are 5 types of writs as given on the screen: habeas corpus, mandamus, certiorari, prohibition, and quo warranto. We'll be understanding them in depth further. Let's understand the most important writ, that is habeas corpus. Now, this is one of the most powerful protections given to citizens. Now, this is a Latin term which means you shall have the body. In simple language, produce the person before the court. This writ is issued when a person is detained illegally, meaning that there is no valid reason for their arrest, or there is no legal authority, or due process is not followed. And the main purpose of this writ is to protect personal liberty. It ensures that no one is kept in custody unlawfully. This writ is issued when a person is arrested without legal reason, detention violates the procedure, and someone is held illegally. Now, some of the important features of this writ is, even if the person is detained, anyone can file this writ on their behalf. And secondly, the court does not check whether the person is guilty or not. It only checks whether the detention is legal or not. Thirdly, this is an immediate remedy. Courts act very quickly, okay? Example is like if police arrest someone without any warrant, okay? And without any proper reason, you can say, then this person can file this writ. And if detention is illegal, the court will order immediate release. So remember that this writ protects you from freedom of illegal detention. In a democracy, no one should be behind the bars without the law, and this writ ensures exactly that. Now let's move to the second writ, that is mandamus. Now this is one of the most practical writs in real life. Mandamus means we command. In simple language, the court is ordering someone to do their duty. This writ is issued when a public official or authority is not doing their legal duty. So what does the court do? Write in the comment section, what do you think the courts do? Pause this video and go there. It commands them to perform that duty, okay? And mandamus can be issued against public officials, government authorities, lower courts, anyone who has a public duty. But remember, it cannot be issued against private individuals because private people don't have public duties. Now, this writ is issued to compel performance of ministerial duties, which means that duties which are mandatory, not optional. Now, pay attention, okay? I need your attention because this is very important thing. Mandamus is not issued in few cases. This is for discretionary duties where authority has a choice. Secondly, if a petitioner has no legal right. And third, if alternate remedy exists. Now let's take an example. If a government officer refuses to issue a license or perform an official duty, you can file mandamus and the court will say, do your duty. So remember, mandamus means court forcing authority to act. In a democracy, power comes with responsibility, and if authority fail, mandamus ensures that they are held accountable. Now let's move to the third most important writ, that is certiorari. This is one of the most important writs when it comes to judicial control. Now, this means to be informed, but don't get confused by the wording because, in simple terms, a higher court checks and cancels a wrong decision. This writ is issued by a higher court to a lower court or tribunal. And what does it do? It quashes, meaning it cancels illegal orders, unconstitutional decisions, arbitrary judgments. The purpose of this writ is to ensure justice, judicial review, control over lower courts, protection from misuse of power. This writ is issued when a lower court makes a mistake, like acting without jurisdiction, making an error of law, violating natural justice. Natural justice over here means, fair hearing, no bias. Let's take a simple example. If a tribunal gives a decision beyond its legal authority, then higher court or supreme court can cancel the decision using this writ. Okay. Now this works after the decision. It corrects the mistake. So remember that this writ is the cancellation of illegal decision of lower court. If in a system of courts where courts can make a mistake, there must be a mechanism to correct them, and this writ ensures that justice is not compromised. Now let's move to the fourth writ, that is prohibition. This writ is very similar to the certiorari, but this difference is very important. Prohibition means we forbid. In simple language, the higher court stops a lower court from doing something. Now this writ is issued by a higher court to prevent a lower court or tribunal from exceeding its power, from acting without authority. Now, to understand the most important part, prohibition is preventive in nature. It works before the final decision. This writ is issued when lower courts exceeds jurisdiction, tribunal acts beyond authority, and natural justice is violated. Yes, it is similar to the last one. Natural justice, as I told earlier, fair hearing and no bias. Prohibition is issued only against judicial or quasi-judicial bodies, not against private individuals, not against administrative bodies in most cases. So hear this very carefully. This is the difference where students get wrong, okay? Prohibition is before decision. Certiorari was after decision. Prohibition stops. Certiorari corrects. Now, let's take a simple example. If a lower court is hearing a case which is not under its jurisdiction, the higher court will stop using prohibition. Okay? So mistakes should not just be corrected, they should be prevented, and prohibition writ ensures exactly that thing. Now we come to the last writ, that is quo warranto. Now this is very interesting. This means by what authority? In simple language, we can say that on what basis are you holding this position? This writ was issued to, challenge a person who is holding a public office if that person is not legally qualified. So court can remove them. The purpose of this writ is to ensure only eligible and qualified people hold public office. This is very important. Any citizen can file this writ. You don't need to be personally affected. It is in public interest. This writ applies to public offices, positions created by constitution or the law, not private jobs. So, for this writ to apply, these conditions must be satisfied. Office must be public, office must be created by law, and person must not be legally qualified. Now, let's take a simple example. If someone is appointed to a government post without meeting eligibility criteria, then any citizen can challenge that appointment using this writ. Okay? This is just the summary of whatever I told you, the fundamental rights that we discussed yesterday, as well as the 5 constitutional rights and the rule of law, that is the protection, you know. So this is to ensure accountability and maintain balance of power in the center as well as in the state. You can go through this slide, and next we'll be doing the suspension of fundamental rights, which is also a very, very important topic for any exam, as well as if you're a citizen of India, you must know that fundamental rights can be suspended under some conditions. Till now, we have understood that fundamental rights protect citizens. But are these rights always available? The answer to this is no. In certain extreme situations, fundamental rights can be suspended, and this happens during a national emergency under Article 352. So the only way through which this can happen, that the prohibition of fundamental rights can occur, is during any national emergency, which is stated in the Article 352. Emergency can be declared when India's security is threatened by either war or external aggression or armed rebellion. During such situations, the government gets more power and some fundamental rights can be restricted. So rights under Article 19 are automatically suspended during national emergency. Freedom of speech, movement, expression, all can be restricted. Now think logically, why would the Constitution allow this? Pause this video, go to the comment section and write down the answer to this question. Whatever you think it is, why would the Constitution allow this? Now, for obvious reasons, the Constitution would allow this because national security is more important than individual freedom, at least in crisis. So after the misuse during past emergency, the Constitution was amended, and the 44th Amendment added safeguards like the cabinet approval required, parliament approval within 1 month. So you need to understand this clearly that fundamental rights are strong, but these are not absolute, as we studied during the fundamental rights slide. States protect the nation even if it means limiting the rights. Only in emergency, but in normal times, rights protect you from the state, okay? So this shows a balance in the Constitution between liberty and national interest. Now let's get one step deeper. Which fundamental rights are suspended and when? This is very important for exams. Focus. During national emergency, under Article 352, fundamental rights stated under Article 19 are automatically suspended. Now, another important point is that other fundamental rights can also be suspended, but only through a presidential order. But you need to remember this very carefully that Articles 20 and Article 21 can never be suspended. That was protection in criminal cases and right to life. These remain protected even during the emergency. Now, how is this emergency approved? It must be approved by the parliament within 1 month. Also understand these two articles. Article 358 automatically suspends Article 19 and Article 359 allows President to suspend enforcement of other rights. Okay, so impact on citizen of all this is that during emergency you cannot go to the court for enforcement of suspended rights, but again remember that 20 and 21 are the two articles which still are protecting you. So even in the worst case scenario, your right to life and protection under law cannot be taken away. So Article 19 gets automatically suspended. Other rights can be suspended by the presidential order, but Article 20 and 21 can never be suspended. This is how the Constitution, carefully gives power to the state, but still protects basic human rights. This shows how nicely the Constitution was designed. Now let's understand something very basic but very important, that how does the Constitution prevent misuse of power? Because we studied that fundamental rights can be suspended, right? But can the government misuse this power? So no. The Constitution provides strong safeguards to prevent arbitrary suspension of rights. The first safeguard says that parliamentary approval. Emergency cannot continue indefinitely. It must be approved by the parliament within 1 month, and this ensures democratic control. The 44th Amendment, 1978, this was introduced after misuse during earlier emergencies, and it strengthened protection by ensuring that 20 and 21 articles cannot be suspended. And the most important safeguard is the judiciary, the Supreme Court. It has the power to examine whether the emergency is valid or not. The judiciary acts as the ultimate guardian of fundamental rights, and it ensures that government does not misuse power, suspension remains temporary, and actions are justified. Now, what happens after the emergency ends? All suspended rights are automatically restored. During emergency, state becomes powerful. After emergency, rights come back. This is the beauty of our constitution, that it allows strong action in crisis but prevents permanent damage to the freedom. It maintains a perfect balance between national security and individual liberty, and that balance is the strength of Indian democracy. A few case studies so that you can connect with them and understand the concept through real events. So, India has faced three major emergency periods. In 1962 during the China War, 1971 during the Pakistan War, 1975 to 77 was an internal emergency, and out of these, the most important is the 1975 emergency. Now, this period is often called the darkest phase of Indian democracy. During this time, fundamental rights under Article 19 were widely suspended. Freedom of speech was heavily restricted, opposition leaders were arrested, and press censorship was imposed. Now comes a very important Supreme Court case, that is ADM Jabalpur versus Shiv Kant Shukla, 1976, I'm sorry. In this case, the court held that even the right to life could be suspended during emergency. But later, this judgment was heavily criticized because it went against basic human rights. And to correct this, the 44th Amendment of 1978 was introduced, which clearly ensured that 20 and 21 are the two articles which can never be suspended in any emergency. So, what do we learn from this? Even if mistakes happen, the Constitution has the ability to correct itself. And after emergency, democracy was restored through elections and stronger safeguards were introduced. This shows that democracy is not just about power, it is about accountability of the mistakes. Indian constitution is not rigid. It evolves with time and learns from its mistakes, so to protect citizens the better way. So always remember that rights can be challenged, but democracy always finds a way to restore them. We discussed protection rights, which rights get, what are the rights and what are they meant for, what is the power of the 32 article, and what are the rights, writs, and safeguards. So this you can have a look on. And in the next lecture, we'll be covering the directive principles of state policy and also some important topics which come under this, which are essential for everyone to understand. So kindly share your doubts or questions in the comment section and we'll be very happy to respond to them. Do not forget to like, share, and subscribe for more content. Thank you and have a nice day.